All right, welcome back, everybody. If you were working over lunch, take a moment, please, to re-engage with the blawforum.app in your browser so you can ask questions of our afternoon panelists. Be sure, while you're in the app, also to network with anyone you've been chatting with and to learn more about our sponsors and, of course, again, ask questions of our panelists this afternoon. If you're on social media, we'd love you to get you involved in the conversation using hashtag #LegalForum. And a reminder, too, if you're interested in receiving CLE credit today, don't forget to sign in and out on the iPads, which are positioned just through those main doors there. All right, it's time for our Ask the Analyst session. I'm really excited about this one. I talked a little bit about the analysts at the beginning of the program today. But basically, they're our subject matter experts. They're the face of Bloomberg Law, and they're dedicated to seeing around corners to prepare you for what's coming next in the legal industry. That includes, of course, topics related to regulatory and compliance issues. So our session today will focus on the investigation process. I'm delighted to introduce Amanda Allen, our team lead for regulatory and compliance at Bloomberg Law. And she's going to be interviewing Patty Tehrani, a legal analyst on Amanda's team. Patty has over 20 years of experience with advising compliance departments prior to joining Bloomberg Law, and so we're thrilled that she can share her insights with you all today. So I'll turn it over to Amanda.
Thanks, Kristen, and welcome to the Ask an Analyst session. You just heard a very brief introduction of Patty's background, but I would like to give her a moment to go a little bit more into depth on the in-house and consulting experience she had before joining us here at Bloomberg Law.
Sure. Hi, everybody. My name is Patty Tehrani, and I've been a compliance counsel for over, let me put it, a couple of decades. That sounds better. I've covered the financial services sector in-house for the most part. I've also done consulting work. My primary area of focus has been policy management in terms of developing and maintaining policies, including creating internal investigations protocols. I'm the legal analyst that covers all good things corporate compliance and regulatory compliance issues that cover and impact the financial services sector.
So one of the things that Patty does for us is she creates these practical guidance documents, and we have a ton of them across the compliance materials that we have, and some of those materials are what Patty has named roadmaps. Everyone's here familiar with the roadmap. And when she lays out her topics from anti-corruption to cybersecurity to, of course, investigations as well, they happen to look like game boards. So we are going to use that visual as the inspiration today for walking through the investigations process, a process that if you weren't already familiar with it before coming into the room today, I think we're all pretty familiar with it by now. Some of you may not like it very much still. But the other thing about the game board is that everyone in this room is really familiar with the concept of gamification, of training, of processes, of interacting with people in your offices. And actually, in fact, one of Bloomberg Law's regular contributors for our Insights columns is Wei Chen, and Wei Chen just recently wrote an entire piece about how you deal with the entertainment versus end result tension when you're implementing a gamified training program. So we are not, in fact, going to debate the utility of gamification in distracting your employees into compliance. We are instead just going to roll with it, and we are going to use the game board to keep your attention for the rest of this session. So on this board, all of these steps are necessary, and I think most, if not all, will have been mentioned already during earlier panels today. So, and you'll notice actually Patty and I both have our rule books with us for getting through this session. It's a little bit less ad-libbed than some of the other answers may have been. People drawing from, I mean, Patty's obviously drawing from experience, but we want to walk you through the game the way that it's played. So, inflection point number 1. You've just landed on scope and misconduct, and if you haven't already determined, Patty, what the investigation's trigger or triggers are, you might end up having to go all the way back to the beginning. So what should you be doing at this point?
Well, I think first, don't go all the way back to the beginning. That's not what you want to do. That could be disruptive. But I think what's really important here is that the triggering event is going to give you some information. But at this point, and as you'll note on the game board, this is the assessment part. And I think it's really important for you to be able to do a triage, because you want to be able to get more information to be able to really plan, which will be very critical. So in terms of the triage, key points here is you want to make sure that you're acting swiftly and that you're not dragging your feet. You want to also make sure that you've assigned it to someone that has expertise and someone whose judgment is going to be critically important, because you're going to rely on that individual and the team that they lead to help define the next steps. The other thing that I mentioned here is that you want to make sure that you have the right size approach. As you're trying to get your hands on what the issue is, you don't want to be thinking about bringing in an army, because that may not be practical or reasonable. So think about that. What's the right size approach? As a result of doing your triage, hopefully you should be able to walk away with a sense of at least what's happened, who's involved, how long, and whether it's still going on. What's the organization's policies that you're going to need to consider? And is this the first time the organization is facing this issue, or is there a history? And also, are there other potential areas that you're going to need to think about? So triage is critically important, and this should keep the momentum going forward. And
I think, interestingly, that triage litany that you just ran through, I think Jacinta from one of the earlier panels today would probably really agree with you. I think she referred to it as, for the issue spotting, she also said spotting the smoke, right? Looking through the data that's available to you and figuring out what might be about to catch on fire. Exactly. You also noted that you don't want to bring in an army, whether that's an internal army or an external army. But let's say that part of this board game is that you have a voucher that enables you to bring in some outside resources, consultants or counsel, to help with the internal investigation. So would you use the voucher now, maybe on Ed from earlier? Oh, he just looked up because he heard his name. Maybe from Ed. Or would you take the approach more like Kate Brennan had at MMC from the same panel? Well, I think Ed and Kate both probably have good points, and I think it really comes back to, and I believe they would agree, it depends on the facts that are involved here. I think what's really important is to, if you have a sense as to how credible and serious the issue is, because frankly, what you don't want to do is bring in consultants or outside counsel who could be very costly. Sorry, Ed. Sorry, Kate. But if you do need to bring them in, you need to be mindful of cost and resources. The other thing that I think is really important too is in consideration of the in-house expertise that you have. You may be dealing with an issue where you just don't have the in-house expertise. So that at that time, the voucher would be a good thing to use. I was at a conference recently, and what I learned there was interesting, is that more and more, especially with sexual harassment cases and whatnot, I think more and more organizations are starting to look at that and bring in outside resources because they want to ensure objectivity and independence. The other thing I would mention here is who's involved. If you're looking at the CEO or if the team is part of the chain of command, again, for purposes of independence and objectivity, using that voucher would be prudent. So maybe one of those sensitive or special investigations that Mark and Kate were talking about on the last panel. So what if you discover that the issue is in fact much larger than you had first laid out in your initial scope and nature outline? And like, if it's all of a sudden 4 times bigger of an investigation that you're going to undertake, do you then go back to the start? Do you skip everything and just end that investigation and restart a new one? Well, I think we heard it today. You don't want to be disruptive. You want to be able to, again, set a tone. There are going to be instances, and I think most of you in the room have faced this, that what you anticipated for, what you planned for, is not quite what you're facing because you uncover issues. I've been part of those scenarios where it's Houston, we have a problem, we need to rethink the strategy. And one of the things that I think has been very useful and very helpful is when you have a much larger issue and a much larger problem, is to deploy a SWAT team. And what is that? A SWAT team, and again, some of you may not call it a SWAT team, that's what we called it, but typically it's a small group of very experienced investigators that can dive right into the situation and in a very short period of time give you a sense as to the gravity of the issues, the individuals involved, and really to be able to even possibly contain it to some degree. So if you're dealing with that kind of scenario where you think this is much larger, it's not a bad idea, instead of throwing yourself off track, to bring in more resources, and a SWAT team approach would be very effective. So when you're doing the SWAT team approach, that's going to be internal. Right. And so if you're bringing in someone external, you want to make sure that they have at least some familiarity with your business the same way that an internal SWAT team would.
Absolutely. Again, I think the last thing that you want, especially if you're dealing with such an urgent issue, is to bring outside resources, or even internally, bring in resources that are not familiar. Because if you're looking at a very defined time period where you need for them to provide the information because of the urgency, you better make sure that it's an outside counsel, consultant, or an internal team that knows what they're doing and knows the organization.
Okay. So you've mapped out your plan and landed on the information gathering and interviewing stage. What you discover as you conduct interviews and gather evidence is far beyond what you had planned for in that stage. So again, is this the end of the game for you?
Hopefully not. I think it's safe to say, once again, that we have all, or most of us have experienced this situation where we're discovering things that we didn't expect or was not part of the plan. So I think when you're thinking about your plan, the mistake that I have seen with planning is that people expect their plans to be perfect. That's not reality. Plans are really good if they are if they put you in a position to map out the key points, the key milestones, but they also need to be flexible. And I think that's really important. So you should anticipate that as you gather more information, collect more information, interview individuals, that you will need to make adjustments and that you may even need more resources. But the thing that you don't want to do is you don't want to stall and you don't want to stop. And this is where I go back to having an experienced leader is really critically important because they will continue the process.
So I can't imagine that changing priorities as you're being flexible into tiny boxes in various shades of green will work well in real life.
Well, again, it's unavoidable. It's reality, and it's, again, part of the process. When you're investigating matters, you're going to come across issues and concerns that you did not anticipate, and as a result, you're going to need to plan accordingly. One of the things that I think is really important is that you are managing the process. The process is not managing you. So what I mean by that is that you want to make sure that you have what I would say is, and again, it sounds more formal than it is, but a communication protocol. Communication is really, really important here. I've been part of investigation teams where we did not know what other members were doing. And as a result, when we would get together, it would be difficult to really reach conclusions or be prepared to go to the next step because we were not informed. The best, I think, scenarios that we faced was when we had communications and we had them on an ongoing basis, not just at the beginning and not just at the end. So I think in terms of managing your process, it's really important that you communicate, and you communicate on a regular basis. You can have team meetings, you can have emails, you can have a whole host of things, but keep the players informed. That will help you manage the process.
And I think that is a key point, and I think we all know that because it's come up a couple of times today in earlier panels. Keeping with our game board theme, let's say we've now taken another turn and landed on initial disclosures. So you just talked about communicating internally, but what about communications to external stakeholders? And should this action be happening at this stage of the game?
Right, and here again, I'm going to give the lawyerly answer, which is it all depends. The reality is when you look at your external stakeholders, you're looking at shareholders, you're looking at consumers, you're looking at governmental authorities, regulators, a whole host of groups. It's going to really depend on a number of things. It's going to depend on the issues. Where I would start first and foremost is the rule books, because you want to first determine whether or not there is a requirement to make a public disclosure. Case in point, the state data breach laws that are out there. You're going to need to disclose, and you're going to need to make sure that you disclose on a timely basis. So there will be time periods. Don't be surprised that you might have to disclose more than once. So that's really critical. So make sure you know what the rules are and whether or not you have a statutory requirement to make the public disclosure. The other thing is that in those instances where there's no requirement, I think we heard this morning about the issue around self-reporting and getting cooperation credit. So this idea of self-reporting is growing more and more, especially in the financial services sector. And it sounds very enticing, and I am a big proponent of transparency and of self-policing. But I think the thing that has to be kept in mind here is that when you want to consider self-reporting, you need to do some homework first. You can't just discover the issue and then call up your regulator and say, I have a problem. What you want to make sure, and I think if you look at the guidelines that are out from the SEC and FINRA in particular, you want to make sure you've done some work. You've done the assessment, you've discovered what the issues are and the players to the best of your abilities. You've contained it or have a plan to contain it. If there's been harm to consumers, there might be a need for restitution to make them whole in some cases. But bottom line is self-reporting is a great tool, but it has to be done with careful planning and thought, and you should be prepared that if you have not done the sufficient work, unfortunately, you may open yourself up to have the regulator come in and do that for you. So keep that in mind.
And in fact, before we move on to the next inflection point that would have segued very well, I just had a thought, which is that Paul, who was on the earlier panel talking about PR and crisis management, I think would emphasize also that while there's self-reporting going on to the regulators, at some point there will be a public statement as well. And that I think you would probably agree that the statement that the person who will most understand the project management of dealing with an investigation that ends up requiring reporting to a regulator is probably not the same person who will best understand how to communicate that issue to the public.
Absolutely. I do think it's important that at the end of the day, when you're thinking about reporting disclosures, whether it's to a regulator, this is not a decision that's made in a vacuum. It does take a village. I've always thought that in order to make the best decisions, they have to be collaborative. So to your point, you may have a crisis management team lead who will be responsible for doing the actual disclosures or making the public announcements. But behind the scenes, you're going to have a number of people that will be involved in making making the decision. Unfortunately, I think, and forgive me for saying, sometimes lawyers and we spend too much time trying to craft the message in a way that becomes very legalistic. You've got to own it is what I really think is important, and you don't want to deflect. I think there was a really good point that Paul made was that there are going to be times when you just don't have all the facts, and you need to get out there and ahead of the game. And we've seen major, major corporations fail to come forward with an effective communication. And that's because they're not owning it. They're deflecting it. And as a result, it seems to me that maybe behind the scenes, there was not the proper discussion that needs to take place.
Okay, so now we've hit on regulators and self-reporting. We've hit on cooperation credit. And I think that in the investigations context right now, where we're about to be at, there we go, the plan for remediation, it connects well with a point made by Jacinta earlier as well, that the DOJ guidelines have resulted in companies really undertaking regular and continuous review of their compliance programs. And I think that that concept is really applicable to the investigations context as well. So can you remediate and investigate at the same time and still be an effective player in this game?
I think you can. I mean, I think the players that are really the best at this recognize that there's not a perfect time to do everything. So what I mean by that, there are internal investigations that you undertake, and then what you come across is, oh, you need to send a reminder out on a policy, or you may need to do a specific training. I don't think you need to hold off and wait until your investigation has been completed to remediate. If you're considering self-reporting, for example, it really does garner some good credits, cooperation credits, if you're in a position to say, by the way, not only did we identify this issue and we're working through it, but we've already fixed some of these problems. Now, there is one downside to that, which
Just
is
one?
Well, multiple probably, but the one that I have experienced myself is that when you have a very long, extended investigation, and sometimes these investigations can take 12 months to 18 months, you shouldn't be surprised that if, for example, if you recognize you needed to update a policy that hadn't been updated in 5 years in month 1, that in month 18, you might have to go back and look at that policy because you've discovered more issues that you didn't know at the time you made the update. So that can happen, but I think that's still perfectly fine. So I do think good players are in a position to be flexible and nimble and be able to make these changes while they're conducting the investigation, and I think there could be some benefit in terms of self-reporting and disclosures.
So in the case where an investigation becomes multi-phase, 12 to 18-month remediation process with ongoing investigating, do you still need to use and rely on the same players for those different aspects and phases of the investigation and remediation?
Well, it's never been my experience that the investigation team is also responsible for remediation. Typically, what I have seen and I've been a part of and what I've written in the protocols is that there is an expectation that you will come across issues that need to be remediated, but you want to make sure that the relevant stakeholders own that responsibility. The investigation team, I think, in this instance, should be kept in the loop, but not necessarily responsible for completing the remediation. And the reason why I think being kept in the loop is important, whether it's the team or the leader, is because at the end of the day, there may be an ongoing need to keep management informed or the governing body of the organization to keep regulators informed. So you're going to want to make sure that the investigation team, at a minimum, is kept in the loop and is informed. But I don't think that it would be prudent that they would need to take on the responsibility for remediation. I don't know that you would have the expertise, and I don't know that you would have necessarily the folks who are authorized or have the authority to do so.
I like your segue. It's like we practiced this.
Yes, we did. We tried. We tried, boss.
So we're now at the end of the game. It's not just the board of directors. It may not even be, in your case, just the SEC in terms of government agencies. How stressful is being the person who has to keep someone informed, producing a final report?
Okay, so
remember, I'm your boss.
Yes, that's true. And reporting bad news is never good, as we know. So here's the thing. I think with the final report, the most stressful thing for me, quite frankly, is quite often the number of people who are trying to have their hand on that report and to define what that report. So I do think what I would say is delivering bad news is never something that anyone looks forward to doing, but I don't view the final report of an investigation as a report on bad news. Instead, I think if you approach it as, we undertook this investigation, we came across, we interviewed individuals, we reviewed the following, and we have, these are our findings. I think the part that's really important and is not focused on enough is the fact that along the way you are also coming across things that you've remediated as well as getting input on recommendations. The recommendations are really the light at the end of the tunnel. I mean, that's when you're telling the people who are ultimately going to be responsible and accountable that not only are we telling you the bad news, but we're also telling you the path to getting these issues remediated or fixed. So that gives them some pause, and then that makes them feel like, okay, this is not horrific, this is not horrible. But also that report is very useful when ultimately the board, CEO, management has to be held accountable by regulators. So it's very important that you use the report as more than just bad news, but also a path to correcting the issues if you haven't already done so, and one thing I will say, and this has been something that has happened along the way, if you are assigning responsibility to a group or a department to fix a problem in your report that you're presenting to the most senior individuals or your governing authority, make sure you confirm with that group that they are willing to do that. Believe it or not, there have been instances where people create reports and they will not confirm with the individuals or departments that they have assigned responsibility to, so that they are going to need to do X, Y, or Z. Because what happens more times than not when you haven't done that step is you find yourself having to go back to the board and say, I'm sorry, I think we made a mistake. We had thought that X group could do that, but instead they can't because they don't have the budget or the resources. So again, having a path to getting things done is great, but make sure you confirm it.
Okay. So we have legal department leaders and law firm leaders in the room who obviously will have run investigations or at least been part of them. Do you have any tips for them from your experience about running the best investigations?
Well, I think what I can offer from a process standpoint is this. I think your objectives should always be to make sure your investigations are as thorough as possible. You don't want to gloss it over and you don't want to rush it if at all possible. I think it's really important at the end of the day to think about the fact that when you're approaching investigations, there is no one size fits all. So bear in mind what the issue is, the nature, the scope, and risk, and I think assign the resources accordingly. The other thing that I would say is roles and responsibilities. It's really important that the people who are on the team know what they're responsible for. So just gathering a team and telling them we're going to investigate something is not enough. You want to make sure that they know what they're responsible for. The triage, I think, is one of the fundamental steps that is critical to the success of any investigation. I also would say communication is really, really important because, as we discussed, you want to keep the players informed. Planning, and again, we're not striving for perfect plans, but a plan that's flexible, that'll give you the key milestones that you need to address. Be realistic and practical in terms of deliverables because resources are limited, and especially if you're going to need to go outside to bring in external resources because of expertise. And make sure, I heard this morning, records are so important. Do not be surprised, especially when you're self-reporting or if you get examined in a future date, that you're going to need to be able to produce records of your investigation and be able to substantiate the conclusions that you reach. If you decided, for example, that you didn't need to take any measures, any steps, you better be in a position to be able to substantiate why you reached that conclusion. And then my favorite, because I am policy Patty and I do think about ongoing process and policies, I always think you need to assess processes on an ongoing basis. What do I mean by that? Lessons learned. If you have the time, pull the folks on the team in a room and say, what do you think worked well? What do you think can work better? And make sure that you factor their input into your process. It's only just going to get better. And then last point that I'll make is having an investigation protocol, if whether it follows this model or not, as we heard this morning, it's not a nice to have. I mean, the DOJ has made it very clear, as we heard, that as part of assessing whether or not your compliance program is working in practice, you're going to need to make sure that you have an investigative practice or process in place.
I think Kristen has at least one question for us.
I think we can have time to sneak in one question. Patty, from your experience and considering the DOJ guidelines from the spring, are companies really doing root cause analysis?
From my experience, I would say that there's definitely the intent to do so. How effective and how robust remains to, could be, is out there for discussion. But I do think that, I think at the end of the day, most organizations want to do the right thing. They want to put the right resources, and they do want to try to assess the situation. But do I think that they do a great job every time? No.
Okay.
Sorry about that.
Thank you. Be better.